Welcome to another edition of our Tech Law video series where we take a deeper dive into the results of the 2024 Tech Index. Today we're going to have a conversation around IP. Let me remind you, the Tech Index looks at all sorts of technology across the world, this year much more than ever before, with 1,200 organizations surveyed around the world. We take the temperature of the tech sector. We look at issues such as AI, 5G, the availability of talent, the availability of funds for tech M&A. But we also look at the regulatory regimes and the adequacy of the IP regimes as they affect tech sector companies. That's what we're here to talk about today. Delighted to be joined by my friends, Marlene, Alexis and Frank. So we're going to get into some of the detail coming out of the Tech Index. There are a few things that leapt out. Written across the index, really large, is AI. And it's amazing because we did this 2 years ago and it was just kind of a bit part. Now you can't move for AI. So maybe we'll come into that in a minute. ESG is in there as well. There's a whole piece around cyber threats, cyber security and data monetization. But let's look at IP. The index looks around the world and looks at the differing regimes. And there's a sense coming out of the index, at least that I'm picking up, that some of the respondents see the European regime as rigid, verging on complex by comparison to, say, a more purposive or flexible regime in the US. Now, is that fair? Is that just what our respondents are saying? Maybe Marlene, if I can come to you first, and we'll just see what you're seeing in your everyday life in terms of rigidity of IP regime.
Yes, I think it's when you look at the AI Act. Of course, you say it's rigid. It's very controlled. It's a difficult act. But I think we will not. Maybe when you see it like that, just the wording, we don't know about the implementation yet, or we don't know how it's going to be interpreted. But But I think I don't think it will be a hindrance for the innovation or development. I do not think so.
Mm-hmm. I concur.
Frank, yeah.
I think it's we have a mixed feeling about this AI Act. Actually, AI Act can look rigid, but if you take a closer look at the IP regime which is involved, you see that there's almost nothing in it. What does it mean in terms of copyright? Mostly, it means that essentially in terms of text and data mining, which could be a very good exception to be used by AI systems or AI system providers, you see that there's no article at all dealing with copyright. You can see that there's only a whereas, which is whereas 105 dealing with it, and which basically says that there's a need for those service providers, those AI providers, to detect whether copyright owners authorize or do not authorize the use of their content. Right. So what it means in short, long story short, it means that the AI Act, in terms of copyright, basically relies on the existing copyright legislation applicable throughout Europe.
Which is not necessarily a bad thing. I don't think with every new piece of legislation you should try to amend and revise the existing IP laws. I always try to convey the message that IP is not there to hinder business, but to the contrary. It's there to foster and encourage creativity. It's there to encourage investments in development generally, in inventions, and that's what it does in reality, at least in my opinion. And I think indeed that the AI Act and any other similar IT regulatory that is coming our way is of course a challenge. You should look at new things through often old glasses, but that doesn't mean that they're not appropriate to cope with the challenges that come our way. And that will be dealt with in case law, I think. We should not try to fill every gap, every uncertainty that comes our way with new legislation.
So don't rush to repaper the world with new red tape when actually you can apply existing principles. But we've already raised copyright and AI here. And I wonder to what extent do you think that this is the new frontier? Because there's some interesting stuff coming along there. You read about George R.R. Martin being very cross that the Game of Thrones manuscripts may or may not have been used to train models and so forth. Is that what you're seeing? Is this the new frontier of copyright actions in terms of the training data for large language models?
We don't know yet about the transparency provisions, how they're going to be understood. Right now, they're written pretty widely, I think. But what if they're actually? I mean, if we're going to have documentation for the data that have been used for training the large language models, it's going to be very difficult. And especially because if we can't, I mean, what has been put in, we can't take it out. So and we don't know that yet. But it's true, I do agree that we do not know. There's not a lot of provisions in the AI Act on copyright or on IP in general.
No, and probably a way to circumvent the issue, especially on the transparency part of the AI Act, you can rely on the 2019 directive on the DSM. The way it has been transposed in the French system, which is not necessarily the most attractive way, and it's where rigidity may arise, is that obviously the exception I referred to a moment ago, which is text and data mining exception, which would help all those systems to work, let's say, freely or more freely. The way it has been implemented, transposed in the French system is twofold. You can either obtain from right holders the authorization to use the content, the protected content, or if you are not able to obtain this authorization, you can use the exception. But the exception under the French system is extremely rigid, unfortunately, because the duration of storage of the protected content on the AI provider servers under the EU system is supposed to last, to be as long as needed. Okay? Under the French system, it is as short as possible. So this is a kind of an issue, and long story short, the CSPLA, Conseil supérieur de la propriété littéraire et artistique in France, is working hard with the EU Commission to identify the best way for the AI service providers to identify the language for them to identify how to opt out and how opt-out has been made.
And that needs to be figured out, doesn't it? Because the providers of the main players need to know how
it's
to...
It's a matter of legal security.
That should be interpreted in the same way in all European countries, I think, because otherwise it's going to be a nightmare if it's not the same.
Really?
Yeah.
And Alexis, do you think that will happen? We mentioned the Brussels effect. Do you think we start in Brussels and ripple that out as a consensual way?
No, but I mean, it's a new story, and at the same time, it's been there, done that. I believe what's happening today, I mean, in terms of regulation, we've seen the same with GDPR, and I heard many countries, especially in other continents, opposing to that, and in the end what we saw was a lot of copying, and there it's important to be the first one to set the tone, also to define terms, to leave case law the room to further shape regulation. That's one. And secondly, what I said, been there, done that, I mean, obviously on another level, but what we see today with AI, we have seen it before, with copy machine in the paper eras, in the 1990s, what happened to the music industry, what happened to the film industry, and you saw the way they suffered for years. Those developers of all those copy tools, they tried to convince the public that that was the new reality, that they should simply accept the new reality. And it took the music industry a few years to get over it, but in the end they managed. And I think that's the era we're entering now. All creative companies that live of that creativity, of exploiting their creative works, they should now simply realize what happens and what steps they should take to cope with that issue, which is simply on a much larger scale than ever before. Yes. They should not just accept reality. They should not just accept that all their works, all their investments are being used by third parties. They should see what do we need to do. And I do believe, as you said, that existing legislation is there to cope with that. Again, on another level, but I think with copyright, and even more, we haven't even talked about trade secrets yet, which becomes much more relevant than ever. It's also a question of not disclosing your confidential information, but simply to apologies.
But trade secrets, but also data. I mean, you have to bring in data protection. You have to say that you do not prompt personal data. You have to be careful about that. So, I mean, trade secrets, confidential information.
Comes with more responsibility.
Yeah, exactly.
Sure.
So the way that you use it, I think we have been very mature in our use of these large language models, and we have to find a new way to do it, to be either to have enterprise versions, to have our own models.
Because the cat is out of the bag, as they say, right? Yes. I was talking to a US colleague the other day who said for some of the organizations, the potential rewards from exploitation of AI tools are so great that they are happy to deal with whatever fine, because it'll be a rounding error by comparison to the upside. Now, that's an interesting approach. Frank, are you seeing that?
No, that's really interesting.
Yeah, it is. Yeah.
And I think getting to your point, Alexis, I think we should not underestimate the pace and the evolution, the quick evolution of the technology here. You said earlier that we discussed this topic 2 years ago. It was totally different. Now we are in the core business. You know, we are within in the heart of the technology, and I think we should not set aside the shift within the technology and the benefits of what could be rewarded to the media business in particular. Yes. You were referring to the US a moment ago. I think, AI was such a revolution that it brought the unions in the motion picture industry, especially on the dubbing side, where, now, I mean, you can use whoever's voice to dub whatever kind of production, okay, with or without his or her consent, and you can do that for free, or almost, which brought which led to the SAG-AFTRA strike 6 months ago. And the whole Hollywood system was upside down. And basically they have to deal with the union in order to find a solution. They have found a solution that I'm not saying which should be inspired by, but that should probably lead to a kind of a compromise, between the capability of tech to serve better the industry, but not with setting the human forces aside. And there was a French proposal, again French, because I mean, France is it's the origin of the copyright system of the droit d'auteur. That's why it's that's it. It's not me, and it was late 18th century. Anyway, the proposal, which is a little rigid, but we should keep it in mind, is to bring peace into this, and in order for we lawyers not to be always behind the facts, is potentially to consider a potential copyright levy, something that would be used whenever it's impossible to identify the copyright holders of what is put in the input to train AI systems, okay, for those collecting societies to collect a light levy, okay, to be redistributed afterwards whenever the output is used.
How much support is this gaining in other jurisdictions as a proposal?
It's always a challenge of being first. So I think we are at the very first stage of that. But I know that the CSPLA is considering it and is bringing this solution with the EU Commission.
Actually, sorry to interrupt,
Alexis,
it's
please,
a similar response as to what we've seen before. To
It
the
is.
challenges that came with the copy machines,
Yeah.
and which may be even... I see other parties in favor of it because it facilitates business, it brings legal certainty, it brings fairness, and it brings...
And security.
And security,
Yeah.
and it brings a new balance between the various interests.
And it brings a lot of new possibilities, options. I was thinking now, you said media, then I'm thinking about sports, and I think about what we have been doing in football to avoid hooliganism. That now we are working on it in Denmark to have these facial recognition systems all over the place to avoid the fighting, fireworks, whatever. And I think that's incredible. Also using the technology, using these AI-based systems. So I think it's we have to think like that out of the box.
So this is really positive what you're all saying, because our tech index is the highest it's ever been. That high number means a high sense that the industry is able to thrive on a global basis. You know, undoubtedly, in the examples you're giving here, we make life more and more complex for ourselves as we go along, and the rules get more and more complex. But looking at the responses, most organizations, well, more than a third of organizations, 1,200 organizations we spoke to, said they are all expecting growth. And in fact, more than a third expecting growth of more than 6%. So it's pretty positive and that's a global picture of a tech sector. And that must be down to understanding and comfort with existing IP regimes. Do you agree? Is that a fair comment?
Absolutely.
Yes,
Yeah.
it is.
It's all thanks to IP, by the way.
It's all down to IP.
No, but the point will be, as suggestion made by Frank, as long as things get automated, it should not be an extra burden upon the companies, upon the industry. I mean, all tools are there also to make such a levy automated and fair, and it should not bring extra work and burdens. That's important, and exactly that's where the tech industry and intellectual property comes together and strengthens each other rather than being counterproductive.
Yeah, and I think what in the tech index report I think was very new to me, very positive, is that in Europe, the companies in Europe, that they take the AI now on very serious, and I think they take it. It's very positive to see that they, even more than in the US, they think that AI can bring, growth into their companies. Mm-hmm. And I think what's very interesting about the report as well was to see that we're not the only one having this FOMO about should we buy, what should we buy from all shelves, or that we're getting on another level now, that we're being more holistic, or we are actually looking at what do we need, what kind of tools do we need. And I think in the way that when we talk to our clients about it as well, we know how to advise them better.
I think it's a matter. I think it's a matter of balance, Mark. Frankly, it's a balance between evolution, which makes our lives better, obviously. At least it's the primary will and intent. And on the other hand, creation, and not to forget the value of the assets that are created. Mm-hmm. And those assets are sometimes, also mostly, sit within the tech companies. So those tech companies who wants to have a quick ROI and easy must take into account the value of those IP assets. Mm-hmm. So that's why, to me, it's a matter of balance. It's a matter of balance.
Maybe that's a lovely point to end on in terms of optimism. We're seeing that in the index, in seeing balance and business common sense. So thank you for watching. You've heard from 3 experts who have commented in more depth on our index from the perspective of France, Belgium and Denmark. The index itself is global, so we commend it to you. We hope you dive in and have a read, because you'll get the perspectives from the US, Asia Pac, LATAM and the Middle East as well. Thanks very much.